We are delighted to welcome our next guest, who's a lawyer at Volkswagen Group Whistleblower System, Angelina Lauer. She's an expert on the German Act on corporate due diligence in supply chains and is currently involved in implementing the requirements of the Act at Volkswagen Group. Before that, she worked for the Coordinator Business and Human Rights Volkswagen Group. Ms. Lauer gained international working experience in New York, Nairobi and Singapore. Besides her German law degree, she holds a master's degree in public international law and politics. According to her, compliance is the basis for trust in a transforming world. By firmly anchoring compliance in our daily business, we are jointly safeguarding the path to the future for ourselves and for generations to come.
Thank you very much. I'm happy to give you a short legal introduction to human rights and corporate due diligence obligations. So, why do we need human rights at all? And what makes human rights so special in comparison to ordinary law? Well, a lawyer would say human rights are the basic rights and freedoms to belong to every person in the world, from birth until death. These basic rights are based on shared values like dignity, fairness, equality, respect, and independence. That means that every human being naturally inherits human rights, no matter where you live in the world. It is your birthright to be treated accordingly. This is the key idea behind human rights, regardless if you find them in national constitutions or international treaties. Looking back in history, we see the idea of human rights have a long tradition, starting with the times of Enlightenment and French Revolution. However, it took some time until the end of the Second World War to be acute, when the UN was established and released the UN Universal Declaration of Human Rights, which is, as a side fact, no legally binding document, rather a firm political statement. Based on the Universal Declaration of Human Rights, legally binding public international treaties were about to follow. In particular, 2 international treaties on civil and social human rights being often referenced in due diligence legislation. However, states are the core subjects of international law and obliged to implement it in binding national acts for individuals and companies. States have the power to establish effective authorities to monitor and enforce compliance with these acts in its own territories. In contrast, companies are legal private persons and do not have the power to protect rights as states do. That is also why human rights violation can be only committed by states and not by companies. Companies may cause negative impact on human rights or may abuse human rights. If you ever wondered about the odd wording in legal documents referring to companies and human rights in this respect. Still, we live in a time of globalization with companies having suppliers from all over the world, also from countries with lower social standards. Companies are connected with the welfare of people around the globe. And tragedies like the collapse factory Rana Plaza sadly shows this more than enough. Because companies should not take advantage on poor labor conditions abroad, in Africa, Bangladesh, or even worsen them. This is the key issue of all the debate around human rights due diligence along the supply chain. We've got a global economy, but national laws which are limited to the border of each state. to close the gap, the UN Guiding Principles on Businesses and Human Rights were passed by the UN Human Rights Council 2011, obliging states to protect and businesses to respect human rights. The latter shall be encouraged to establish fair and social labor standards in their company and in their supply chain, as far as they can have control over them. The UN Guiding Principles are so-called soft law. They are not binding for states, but were a strong recommendation to them to implement the content of the UN Guiding Principles into national law. In short, the state may comply with their duty to protect human rights by adopting acts which oblige companies to respect human rights. Well, we don't have the time to go into detail. National and EU legislator were hard working. There are just few national and EU legislation or legislative proposals with regard to businesses and human rights. Roughly, we may distinguish 3 types of acts dealing with human rights. First, reporting obligations on due diligence, like the UK Modern Slavery Act or the EU taxonomy. It is the key idea of transparency behind and the softest way to oblige companies to respect human rights. Second, we have pure due diligence obligation as proposed by the UN Guiding Principles, often being linked with sanctions or civil liability for being incompliant with due diligence obligations. Here the state already uses its monitoring power to protect human rights. Third, we've got sanctions. Most prominent and pressing example is the US Uyghur Forced Labor Prevention Act, imposing stringent import restrictions for goods being tainted by the use of forced labor. It is a sort of take it or leave it method. So sanctions seems to be the most effective, prompt and demanding way to remind companies of their duty to respect human rights. And it gets even more confusing if countries like China adopt countermeasures to the US Act, like the Chinese Anti-Foreign Sanction Law, with the aim to sanction companies which comply with foreign sanctions in Chinese territory. How these legally conflicting acts are to be dealt with in practice still appears a mystery. Let's have a closer look now on the proposal of the EU Corporate Sustainable Due Diligence Directive for all the Due Diligence Act as an example. And if I say EU Directive in the following, I always refer to this proposal by the EU Commission, just to be clear about my wording. Well, I tried to reach the impossible and pin the whole directive on one slide by simplifying it to the minimum as the big picture. So first, in-scope companies must carry out due diligence on actual and potential adverse human rights and environmental aspects arising from their own business operations, those of their subsidiaries, and were related to their value chain from the established business relationship. Second, very large companies must also adopt a climate plan to ensure that their business model and strategy are compatible with the limiting global warming to 1.5 Celsius degree in line with the Paris Agreement. These are the 2 main obligations of the EU directive, performing due diligence and adopting a climate plan. Third, directors of very large EU companies must now take into account the consequences of their decisions for sustainable measures, including human rights, climate change, and environmental consequences. For example, they must set up and oversee due diligence policies, processes, and actions. And fourth, EU directive also propose administrative supervision, enforcement, and complaints, as well as civil liability in the event of violations of due diligence obligations. The main issue about the EU directive, as well as the German Supply Chain Due Diligence Act, is that both include many uncertain legal terms to be interpreted by companies, first in the hope that supervisory authorities or courts will follow and regard their implementation of due diligence as sufficient and appropriate. Just an example for this uncertainty. A raging debate has already been ignited about the definition what value chain and established business relationship mean and which constellation are covered or not covered. So, having a brief look at the in-scope companies, the EU directive splits them into 4 groups. And even though SMEs, small, middle-sized and medium enterprises, have been completely excluded from the scope, there will be real-world implications for SMEs in Europe and beyond. So, being a supply chain of in-scope companies. Therefore, the EU directive includes provision designed to support SMEs. When performing due diligence, in-scope companies will need to be alert to the potential implications for SMEs and require to bear certain costs, for instance, cost of independent third-party verification. So what that requirement would actually mean in practice still remains unclear. I would like to make a deep dive on this and the next slide, because due diligence is the core legal requirement here. So what does due diligence include in detail? First, companies must integrate due diligence into all of the policies, like a due diligence policy or a code of conduct. Second, companies must take appropriate measures to identify actual and potential adverse impacts. This is the risk analysis in the German Act. Third, companies must take appropriate measures to address those adverse impacts. The measures of companies are required to take depends on whether there are potential adverse impacts or actual adverse impacts. Or in the wording of the German Act, preventive measures for risk and remedial actions for violations. Fourth, the company shall monitor the effectiveness of due diligence policies and measures by the way of periodic assessment, at least annually. Fifth, the company must establish and maintain a complaints procedure in order to investigate complaints. Big companies already have set up whistleblower systems. So if such a complaints procedure is included in the whistleblower system of a company, EU Whistleblower Directive or the German Act of Transposition has been taken into account too. And sixth, companies must publicly communicate or report on the company's due diligence obligations and policies, unless the company is already required to report by the EU Non-Financial Reporting Directive or its predecessor forthcoming Corporate Sustainable Reporting Directive. Here's the difference to the German Act, which does not make this exception. So still 2 reports for big companies in Germany. So if you are shocked now by this overloaded slide, I must confess I did it on purpose. Because the legal key question of all is, what are adverse human rights and environmental impacts? I put the environmental impacts on the next slide. Sadly, they did not fit on this one anymore. So what can we say that adverse impact is, when can we say that adverse impact is legally and practically confirmed as true, with the consequence of performing further due diligence and being liable or sanctioned for failure? Because only if adverse impacts are identified and affirmed, the companies need to take action in a second step. And this second step will be thoroughly investigated by a supervisory authority and civil court if it comes to the pinch. So let's take a fictive example. Your company may receive a complaint that an indirect supplier in China does not comply with the human right to life and security because he does not offer facial corona masks to its employees, and 10 employees already died of corona. In addition, a trustworthy witness says it's true. No facial masks were worn at production site and people had died. In addition, it seems likely the contagion happened at work. First, just by your gut feeling, would you think that this is already an adverse impact on human rights if the accusation is correct? In general, what's the threshold? If you compare this case with the other human rights like prohibition of forced labor or child labor and so on, that are really severe and abominable crimes, violations where you instantly feel at the first second these are totally against your morals, your ideals, and what you believe in. Furthermore, companies will not have the financial and personal resources to investigate any ordinary breach of law by its suppliers, and it's also not what the legislator intends. But reality is normally grayish and not black and white. In my case, no facial corona mask and people died. What precisely is expected from the companies? Shall a company lawyer check advisory comments to international treaties and international case law when existing what the threshold of violating the human rights to life and security may be? Or shall the lawyer do some research on Chinese corona regulations in order to assess if the indirect supplier complies with it? If yes, is the company allowed to close the case? If no, does the company lawyer need to assess if an ordinary breach of Chinese corona regulations might also be a breach of Chinese fundamental rights or a hypothetical breach of an international human rights treaty which China did not ratify? Normally, only national constitutional courts are allowed to decide on these legal issues. And I'm not even sure if a German authority or German civil court is allowed to do so without interfering with the international principles of sovereignty. So in such cases, companies need guidance by the EU and German government what to do. In particular, if they have plenty grayish cases to assess with limited resources. So just to conclude, what are the next steps of the EU directive? To become a part of the EU law, the text of the proposed EU directive must be adopted by the co-legislator, the European and Council of Europe, the European Parliament and the Council of the EU. It is difficult to predict how long the process will take, but anything between 18 and 24 months. the directive would come into effect then